So, good evening, everyone. I hope you all are doing fine, staying safe home. Well, today's topic for presentation is uh, prisons during pandemic and reforms needed. See, when we talk about coronavirus or its prevention, when we talk about any epidemic disease that spreads through community transmission, that has the ability or that has the feature, of being transmitted through communities and through people, from people to people, then in that case the best option is to isolate yourself inside your homes and staying safe, keeping a distance. Even if you are visiting a crowded place, even if you are visiting a place where people, even in small quantities, even in small numbers, they have gathered, then in that case what you are supposed to do, since 2020, that's what we have been learning, that this disease, in the second wave, we have seen it's almost incurable. Only the fortunate people whom Allah blessed, with a healthy life and a long life, they could save themselves. They could be saved. They could, endured this harsh disease. But most of the people, we have lost our loved ones this year also. So this disease I was talking about, that it has a nature of community transmission. Community transmission means that we cannot visit a crowded place, we cannot visit the marketplace like this. We have to, even the doctors, yesterday I had a talk with a doctor from Aligarh Muslim University. He said, there is no proper treatment for coronavirus, there is no proper treatment for these kinds of pandemics. It takes time for the scientists and the doctors to discover what disease is all about. Right now we are calling it a COVID, but it is undergoing certain variations. It is in the process of evolution every day. You never know what kind of a mutant is somebody's body, is inside somebody's body. So the only thing that you can do is to practice prevention. You have to take care of precautions, you have to observe precautions, and you have to make sure that you do not do anything of that sort that leads to community transmission of these kinds of disease. That means you have to isolate yourself, you have to keep a distance of 2 meters, and you have to wear this mask. When we are talking about preventing such kinds of diseases, or making sure that the community transmission of these kinds of epidemics does not take place in our society, at the same time we are ignoring the plight of prisoners inside the prisons. The inmates inside the prisoners, if one inmate becomes positive, COVID positive, because according to the latest report of the WHO, this is, if some COVID positive patient is present inside in one premises, then the germs of this virus, they are present in that particular atmosphere, and the other person who is vulnerable and who does not have a certain level of immunity might get affected, might get infected from this virus. Just think how the inmates are coping up inside the prisons during the pandemic. Don't you think this is a disaster? Don't you think this is a sheer violation of their fundamental rights? Don't you think it is a violation of basic rights? This is so inhumane. Basically, if we see this, it is very inhumane to leave the inmates like this. There are so many inmates inside one cell, so it becomes very difficult to find a solution also at the same time. So when Amitabh Bachchan on the phone says that दो गज की दूरी और मास्क है जरूरी, तो हमें 2 गज की दूरी भी रखनी है, हमें मास्क भी पहनना है, but we have no arrangements, almost no arrangements for the prisoners, because prisoners, they are living up, they are coping up in the same conditions as they used to before a pandemic. There is no proper arrangements made for their social distancing, for observing social distancing inside the prisons. At least one prisoner should be inside inside one cell. Two people should not stay together. What if some prisoner is infected, is a patient of diabetes? What if some prisoner is a heart patient? Or what if some patient has a low level of immunity, is very weak? How do we have to cope up with these kinds of situations? These kinds of situations are very complicated, very challenging, and it is the responsibility of the state to look after these kinds of solutions. But right now, there is an article that I came across in the Hindu, written by Gopal Krishna Gandhi, a former diplomat and a former governor of West Bengal. He has written that being tethered to bars during a pandemic. What happens that when a person is being tethered to bars during a pandemic, we have to see that what kind of reforms that are needed, whether it is the responsibility of the central government or is it the responsibility of the state government. We have to make sure that whosoever's responsibility it is, this has to be looked after properly, because if not looked after properly, then there's going to be a disaster inside the prison, which has taken place undoubtedly, although it was not reported by media, although it was not reported by somebody else, and not even by the social media. But what is happening inside the prisons, only the prisoners can tell you that what they are going through. So I'm starting to share the screen to show you that I have made them into bullet points. Let us see. So this is an article I'm written by Gopal Krishna Gandhi. So being tethered to during a pandemic. See, a distance of 2 yards, दो गज की दूरी, and also they have not written it, mask है जरूरी. ये भी जरूरी है यहाँ पे कि मास्क बहुत जरूरी है. क्या हमारे पास प्रॉपर अरेंजमेंट्स हैं इनसाइड द प्रिजन्स के हम जो है वो इनको प्रॉपर पैंडेमिक के जो प्रॉपर गाइडलाइंस होती हैं हम उनको फॉलो करने को बोलें, तो क्या प्रॉपर अरेंजमेंट्स हैं हमारे पास? A distance of 2 yards, 2 गज की दूरी, we are enjoined to maintain between oneself and anyone else. The pandemic message is relayed on recorded caller messages in all our official languages. अभी ये सारी हमारी जितनी भी ऑफिशियल लैंग्वेजेस हैं यहाँ पर एक मैसेज रिले हो रहा है ना? अमिताभ बच्चन बोलते हैं उसमें कि COVID-19 is not over yet and we have to maintain a distance of 2 yards at least from each other and wear masks regularly. So, but there is a category of persons by which the injunction cannot be observed, and those are prisoners. By the very nature of their situation, the physical limits of their confinement, they are obliged to stay in poorly ventilated and overcrowded cells. This has already been very challenging since beginning. What the prison reforms, because the National Human Rights Commission also has time and again intervened in these matters, that proper and hygienic conditions should be ensured for the prisoners inside. And Dr. Kiran Bedi, when she was serving as IG Delhi Police Research and Development Cell, she made sure that these kinds of things, these kinds of reforms are immediately and necessarily needed, because they are at the end of the day, they are also human beings. No matter they have committed sins, they have sinned, they have committed crimes, they have committed offenses of heinous nature, but at the same time are we should not put them or subject them to inhumane torture. So reforms are needed. So, but there is a category of persons by which the injunction cannot be observed, prisoners. By the very nature of their situation, the physical limits of their confinement, they are obliged to stay in poorly ventilated and overcrowded cells. Cells were initially overcrowded, they were poorly ventilated. Being holed up in that condition almost seems to form part of the punishment. A jail and a dungeon are almost interchangeable terms. I don't know if you have seen some films, some Bollywood movies, wherein it has been realistically shown that what is the actual condition of prisons from inside. I'm not talking about some filmy kind of depictions. I'm talking about the realistic cinema. Perhaps you might have seen many things on the OTT platforms like Amazon Prime or Netflix, wherein they must have shown you some things like this, that the conditions inside the prisons are horrible, actually horrible. And I'm repeating this, that the National Human Rights Commission, if you visit the website of National Human Rights Commission, you would come across that it has worked, it has intervened time and again to improve the conditions, the living conditions of the prisons. There have been various reports, there have been various suggestions, various committees have been formed time and again to make recommendations and suggest measures for making the prisons better for living for the inmates. Again and again this has happened. Former IPS officer Kiran Bedi also made sure that these reforms come immediately, and they should come from the state. Nobody else can do that. So already the prisons which were poorly ventilated, already the prisons which were overcrowded, they were almost like the dungeons. What is a dungeon? If you have visited, you must have seen some jails in the forts, in the medieval structures. If you have visited के monarchy के time में, medieval times में, ancient times में जो राजा महाराजा होते थे, इनकी जेलें कैसी होती थी, इनकी जो जेल्स होती थी ना, वो बड़े खतरनाक होती थी, गुफा टाइप्स होती थी, नीचे जाके टनल में बंद कर देते थे. It used to be a solitary confinement. It used to be almost completely dark inside, and the prisoner had to stay inside that dark room, had to go. So that was a kind of dungeon. It was horrible. So our jails and dungeons are almost interchangeable terms. If you visit the jail, you'll come across that these jails are all and dungeon are almost like interchangeable terms. There's almost no difference left now. So criminal justice has activists in the United States observing with a sharp eye prison conditions. यूनाइटेड स्टेट्स में इन्होंने कहा कि क्रिमिनल जस्टिस के कुछ एक्टिविस्ट हैं जो बहुत शार्प आई से ऑब्जर्व करते हैं कि प्रिजन की कंडीशंस क्या हैं. We do not have in numbers. We have lot of environmental activists, we have a lot of political activists, we have a lot of social activists, and we have a lot of religious activists also, but we do not have criminal justice activists. People, they temporarily make themselves criminal justice activists only when something happens. Like Nirbhaya was brutally gang raped on the night of December 16, 2012, on the streets of Delhi. People came out because they made themselves the criminal justice activists. But criminal justice is also something else. We need to look beyond the conditions of the victim also sometimes, because we have to think from the perspective of the prisoners as well. Sometimes it is necessary, because they are also, at the end of the day, human beings. They need humane treatment. They expect many things. Okay, so criminal justice has activists in the United States observing with a sharp eye prison conditions. We do not, at least not in the same numbers or with the same capacity to influence policy. Writing in Diplomatic Courier on December 29, 2012, Carolyn Nash reported that in March 27 last year, a letter signed by over 40 public health experts called Federal Prisons and Immigration Detention Centers breeding grounds for uncontrolled transmission of the virus. Since in February or in the first week of March, perhaps, I do not exactly remember when the WHO declared this coronavirus as a pandemic. So Caroline Nash reports that March 27 को एक लेटर लिखा था पब्लिक हेल्थ एक्सपर्ट्स ने, 40 पब्लिक हेल्थ एक्सपर्ट्स ने, और उसमें इनवाइट किया था फेडरल प्रिजन्स एंड इमिग्रेशन डिटेंशन सेंटर्स के लोगों को, और वहां पर एक अटेंशन कॉल करी थी कि ये जो फेडरल प्रिजन्स हैं और इमिग्रेशन डिटेंशन सेंटर्स हैं, they have become breeding grounds for uncontrolled transmission of the virus. By September, 44 of 50 COVID-19 clusters were found to be located in prisons. Clusters were made ना, आपने देखा होगा कि क्लस्टर्स जो हैं वो बन रहे थे कि ये वाला क्लस्टर में सबसे ज्यादा ब्रीड कर रहा है वायरस, इस वाले क्लस्टर में ही हो रहा है। और आरोग्य सेतु ऐप जो है हमारा वो मुस्तकिल बता रहा था दिस ग्रीन एरिया, दिस ब्लू एरिया, इस ऑरेंज एरिया। तो ये जो नोटिफिकेशंस थे ये हमारे, ये इससे पता चल रहा था कि कहां पर कितना ज्यादा खतरा है। तो इन्होंने ये कहा कि ये ब्रीडिंग ग्राउंड बन चुका था कोरोना वायरस का। डिटेंशन सेंटर्स और फेडरल प्रिजन्स जो थे ये ब्रीडिंग ग्राउंड्स बन चुके थे। COVID-19 clusters were found to be located in prisons. In Texas, the virus had by then killed more than 230 people in jails and prisons, 80% of whom had not been convicted of a crime. This is again tragedy over tragedy. You know what? There's almost a great injustice inside the prisons, because sometimes the under trial prisoners, they have to stay along with the convicted prisoners. There is a difference between the convicted prisoners and an under trial prisoners. Convicted prisoners are the ones who have been convicted. The evidence was found to be against them and the court pronounced a judgment against them. The court convicted them of the offense they were accused of committing, and the punishment was also pronounced by the court. So they are actually serving the jail term what has been pronounced by the court. So that is conviction. What is under trial prisoners? Under trial prisoners are who have been accused of serious offenses, whose trial is pending before the court. It is going on, it is already going on. There is no final decision of the court yet, but still they are being tethered to behind the bars because they have not been granted bail, because owing to the heinous nature of the crime they have been accused of committing. So basically, even if they have not committed, for instance, even if they have not committed that crime they have been accused of, then don't you think it is a great miscarriage of justice that an under trial prisoners who is simply accused of committing a heinous crime is being tethered to stay behind the bars, is being forced to stay behind the bars along with a convicted prisoner? Do not you think a lesser punishment or a separate arrangement should already have been made for the under trial prisoners? तो ये तो बहुत ट्रेजेडी के ऊपर ट्रेजेडी हो गई कि कन्विक्टेड तो जो थे वो तो मरे ही, लेकिन उनके साथ वो अंडर ट्रायल भी मर गए। 80% जो थे वो कन्विक्ट नहीं हुए थे। हो सकता है उसमें से कितने इनोसेंट होंगे जो बेकार में सिर्फ जिनके ऊपर एक्यूजेशन था, जिन्होंने शायद क्राइम किया भी ना हो। By November, the number of cases in Michigan prisons more than doubled in 2 weeks. और नवंबर में नंबर ऑफ केसेस मिशिगन प्रिजन्स में डबल हो गए 2 हफ्तों में। A Minnesota organizer called his state's soaring rate of prisons infection a human rights disaster. He said it is a human rights disaster, she said. England and Wales have 121 prisons housing about 79,000 prisoners. As the novel coronavirus grew alarmingly in Britain, a mass testing program commenced for all prisoners in 28 of these prisons in July, starting with symptomatic prisoners. This is yet again another challenge. Separating the prisoners testing positive with the ones who were tested negative. Then symptomatic alag, asymptomatic alag. सिम्टोमैटिक में ट्रांसमिशन ज्यादा जल्दी होता है, एसिम्टोमैटिक में ट्रांसमिशन कम होता है। ओके, सो सिम्टोमैटिक प्रिजनर्स के साथ स्टार्ट हुआ। द यूनाइटेड किंगडम मिनिस्ट्री ऑफ जस्टिस फिगर्स, दिस इज रिपोर्टेड इन द गार्डियन ऑफ November 2020, शो दैट प्रिजनर्स टेस्टिंग पॉजिटिव इन सितंबर stood at 883. By October, the number rose to 1529 with 5 deaths. This is a human rights disaster. This is a human rights disaster. Wherever it is taking place, it is a disaster, be it in India or in Britain or in the United States or in any corner of the world, in any country. So basically, what we have to ensure is that prisons, no matter if pandemic is there or not, already must have had reformed the living conditions or improved the living conditions of the prisoners, of the inmates. There should have been made separate arrangements already for the under trial prisoners. They should not have been forced to stay with the convicted prisoners. And also during a pandemic, they should not be, at least all the under trial prisoners or maximum under trial prisoners should have been granted bail for easing or relaxing the number of people inside the prisons. Okay, so this rise was doubtless computed on account of increased testing. Do we have such a statistics for India? They do exist, surely, but not in handy. We do not have all handy's informations right now. It may be available in tidbits. It may be available in scattered forms, but it's not handy right now. So they do exist, surely, but not in handy, ready form in the public domain. Like they are not in ready form, you cannot put it in the public domain. But the tragedy in human terms is that such statistics are not being demanded of our criminal justice system. In the United States and in the UK, pandemic control in prisons is being driven by enlightened public opinion. This is yet again another issue. Pandemic control in prisons. How to control pandemic in prisons? This suggestion was sought from the public. The people who were elected by the citizens, they did not solely use their own minds. They sought the help of the public opinion. And it's important in a democracy to seek the help and seek the opinion of the public in such cases. What kind of reforms are needed? When you consult different intellectual minds in a society in such cases, in such situations, definitely there comes different solutions and different options are available before you on the desk. So this is not surprising in a society such as ours, which seems to have concluded prematurely that the novel coronavirus is behind us, which is not the case. But more pertinently, this is not surprising in a society that has a poor tradition of human rights activism. Like we have a very poor record of human rights activism. We are temporary activists. We are timely activists. We come out of our homes, we come out of our comfort zones only when it is needed. When something is hammered on our heads, only then we step out of our house. Then we come back to our senses. No, it's getting dangerous. We have to stand up. We do not understand it at the moment we should. So it is important for us to understand that in a democracy like ours, it is pertinent for the people who have been elected or who are sitting in the ruling establishment, that it is important for the public to intervene in such matters and make suggestions to the government that under trial prisoners should be looked after, especially at the first priority. They should be released, they should be granted bail in such cases so that they can stay there inside their homes. Obviously, if during a pandemic during a lockdown or during the spread of a pandemic, there are bleak chances of such prisoners being absconding. Okay, तो abscond करने का बहुत ही कम चांस होता है ऐसी सिचुएशन में. So there is no harm in granting bail in such cases. So this is not surprising in a society such as ours, which seems to have concluded prematurely that the novel coronavirus is behind us, which is not the case. But more pertinently, this is not surprising in a society that has a poor tradition of human rights activism. It takes a prominent prisoner such as the writer Varavara Rao or the Khudai Khidmatgar Faisal Khan going down with the virus of the enormity of the disease combining with imprisonment to dawn on us. This was a writer, Varavara Rao, and he was a prominent prisoner because he was imprisoned behind the bars. And then Khudai Khidmatgar Faisal Khan, they were like affected, they got infected with the virus, and they had to face two great pains. One was the imprisonment itself, and the other was the virus. that are 1,400 or so prisons housing over 4.5 lakh prisoners are breeding grounds for the virus does not occupy our thoughts, even our virus related thoughts. But how about the Indian state? You know, we think about ourselves, we think about the slum dwellers, we think about, the clusters, but we do not think about what the prisoners are going through. So we have around 1,400 prisons, which housing over 4.5 lakh prisoners, and they became the breeding grounds for the virus. No reports, no media coverage, no activism, no public protests, nothing, no demands, ना तो स्टेट की कोई तवज्जो उधर गई, ना स्टेट की कोई अटेंशन उधर गई है, ना किसी एक इंडिविजुअल की उधर गई है. So how about the Indian states? Now let us see the Prison Act of 1894. The Prisons Act of 1894 makes prisons the exclusive responsibility of the state governments. अब देखिए यहां पर बहुत क्लियर और साफ अल्फाज में लिखा हुआ है that the Prisons Act of 1894 makes prisons the exclusive responsibility of state governments. Over the years, the condition of prison life has moved up on the human civility and dignity scale, with the venues now being called correctional homes and over 60. I'm sorry, there's a misprint here. Over 60 minimum security open prisons have been set up. Okay, so the Prisons Act of 1894 makes it the exclusive responsibility of the state governments. I remember that I told you, or I discussed it earlier in the earlier sessions, also in the preceding sessions, also that law and order, prisons, public order, crime, these are all things of local nature to be looked after at the local level, at the grassroots level. So these things are included in the state list, in list 2, contained under 7th schedule of the Constitution. We have 3 lists, list 1, 2, and 3, union list, state list, and concurrent list respectively, and the residuary subjects also. And they are contained under Schedule 7 of the Indian Constitution. So over the years, the condition of prison life has moved up on the human civility and dignity scale. So it is the exclusive responsibility of the state government, and then condition of prison life has improved, no doubt about it, because some venues have been changed into correctional homes, and some over 60 minimum security open prisons have been set up. But of the 4.5 lakh prisoners that our correctional homes hold, according to the National Crime Records Bureau's report for 2019, about 3.3 lakh are under trial prisoners against whom investigation or trial is supposed to be in progress. तो एनसीआरबी के रिपोर्ट के अनुसार जो 2019 में निकल कर आई, 3.3 लाख जो हैं 4.5 लाख में से वो अंडर ट्रायल प्रिजनर्स हैं. अब इससे आपको अपने रेट ऑफ कन्विक्शन का भी अंदाजा हो जाएगा कि हमारा रेट ऑफ कन्विक्शन कितना स्लो है. हम 4.5 लाख प्रिजनर्स हमारे पास हैं, जिसमें से सिर्फ 1 लाख कन्विक्टेड हैं और तकरीबन 1 लाख कन्विक्टेड हैं. 3.3 लाख प्रिजनर्स अंडर ट्रायल प्रिजनर्स हैं. अभी उनके खिलाफ इन्वेस्टिगेशन और ट्रायल प्रोग्रेस में है, पेंडिंग है, चल रहा है. कोई जुडिशियल कस्टडी में है और कोई किसी की बेल रिजेक्ट हो चुकी है. तो आप समझ रहे हैं ना यहाँ पे रेट ऑफ कन्विक्शन भी हमारा कितना खराब है. अब इसमें से कितने लोग इनोसेंट हैं, कितने लोग मर रहे हैं उसी ब्रीडिंग ग्राउंड में रहना. एक तो प्रिजन में रहना पड़ रहा है, ये क्या कम सजा है. आप सोचिए कि एक इंसान प्रिजन में रह रहा है, वो अंडर ट्रायल प्रिजनर है, बाद में ये साबित हो जाता है कि उसने ये जुर्म नहीं किया, तो वो जो उसकी जिंदगी के साल बर्बाद हुए हैं, जो उसने टॉर्चर झेला है वहां पर प्रिजन के अंदर, कैन समबडी रिकम्पनसेट इट? कैन समबडी रीइंबर्स इट? Nobody. Nobody can, give his lost years back. So ऐसी सिचुएशन में अगर पैंडेमिक आ जाए तो, अभी ऊपर बताया था कि यूएस में 80% प्रिजनर्स जितने मरे ना, उसमें से 80% जो थे वो अंडर ट्रायल प्रिजनर्स थे. So these 3.3 lakh under trial prisoners have been detained under section 167 of the CRPC, which provides for procedure when investigation cannot be completed within 24 hours. Okay, so section 167 CRPC says that that procedure when investigation cannot be completed in 24 hours. You all must have read CRPC and IPC. So what does this says? We have under Article 22 of the Indian Constitution certain rights during arrests. One of them is that the detainee has to be produced before the nearest magistrate within 24 hours of his arrest, excluding the time of journey from the police station to the place of magistrate. So within 24 hours, he has to be produced before the nearest magistrate. But this detention period can be extended if the magistrate thinks fit. Under section 167 of the CRPC, they have this provision that if the investigation cannot be completed in 24 hours, sometimes most of the time crimes happen over a period of time and over certain places. So it becomes very difficult for the police to collect and gather evidences, and it is a time-consuming job indeed. So 24 hours are in most of the cases are not enough. So the police always seeks a time more than 24 hours and makes a request before the magistrate that the person be detained beyond 24 hours of his arrest so that we can complete our investigation peacefully. We should not remain anxious while we conduct our investigation and gather our evidences that this person who is one of the suspects should not abscond. हो सकता है कि ये abscond कर जाए तो ये टेंशन हमें रहेगी. So it is better that he's a suspect so that he must be put behind the bars. So section 167 of the CRPC provides for procedure when investigation cannot be completed in 24 hours. Okay, so basically 3.3 lakh prisoners are under trial prisoners out of 4.5 lakh. And they are simply being held back because under section 167 of the CRPC, only because the investigation of the crime they have been accused of could not be completed in 24 hours. And in most of the cases, they are staying behind the bars for an indefinite period. Don't know when it's going to end. Okay, so the original CRPC, the earlier one, 1898, the original CRPC of 1898 specified the period of detention as 15 days. This has by amendments been extended to periods that can go up to 90 days, and in some exceptional situations even indefinitely. You must have read section 167 CRPC. It says that for 14 days, 15 days, then 60 days, then 90 days, and then indefinitely. If the crime is of a very heinous nature and it seems that the police needs a good length of time to investigate and gather evidences against him, then can be sent indefinitely. Or this 15 days period or the 60 days period or this 90 days period can alternately be extended. Okay, so this has by amendments been extended to periods that can go up to 90 days, in some exceptional situations even indefinitely. Surendra Nath, former additional secretary in the Ministry of Justice, Government of India, and member of the Constitutional Conduct Group, has pointed out of 3.3 lakh, about 2.2 lakh are either not likely to be even charge sheeted or they are likely to be acquitted. See, some cases, some acquisitions are so weak and so baseless that it seems that out of 3.3 lakh prisoners, 2.2 lakh are not even likely to be charge sheeted. Can you understand this? This is a serious situation. Forget about pandemic. This is even serious without the pandemic. Without a pandemic. See how a person is subject to great torture when, like, how can you think, like, a person who is simply accused of committing a crime, there is no evidence against him, somebody like seeking a vengeance or seeking a vendetta against him have accused him of committing a crime which he has never committed. He's being put behind the bars unnecessarily. He's not even likely to be charge sheeted, or he is most likely to be acquitted. Just think of it, how torturous, how inhumane it is. And what adds more to this problem, what add more to this pain, this pandemic. That in such situations, when prisons became the breeding grounds for this coronavirus, these 2.2 lakh prisoners who were not even likely to be charge sheeted or were most likely to be acquitted were supposed to, or were being tethered to behind the bars during the pandemic. This is so tragic. This is so inhumane. So Surendra Nath, a former additional secretary in the Ministry of Justice, Government of India, and member of the Constitutional Conduct Group, has pointed out of 3.3 lakh, about 2.2 lakh are either not likely to be even charge sheeted or they are likely to be acquitted. Okay, B.D. Sharma, a former head of correctional services in West Bengal, who has done amazing work in giving that nomenclature true meaning, describes their condition thus. Quote, this huge violation of the basic human rights of under trial prisoners, UTPs means under trial prisoners, in such large numbers is made further unbearable by overcrowding, poor living conditions, inadequate healthcare facilities, and torture by other rowdy prisoners, which often occurs with the connivance of jail staff in our prisons. You know what happens? You know what happens inside the jail? Most of the, small skirmishes or affrays, they take place with between the prisoners, between the inmates जो है आपस में लड़ जाते हैं. कभी कोई कहीं का गुंडा है, कहीं कुछ हो रहा है, कहीं कुछ हो रहा है. कुछ लोग जो है वो जेल एडमिनिस्ट्रेशन के खास आदमी होते हैं, खबरी होते हैं, उन्हें हर चीज पहुंचानी होती है. कौन प्रिजनर क्या डिस्कस कर रहा है, किसके बारे में क्या ओपिनियन है, किसका क्या इरादा है, कौन कहां जा रहा है, क्या बात कर रहा है, क्या कर रहा है. तो ये जो खबरी होते हैं ना, छोटे छोटे LIUs, ये छोड़ दिए जाते हैं और ये प्रिजनर्स में से ही होते हैं. ओके, तो इनमें आपस में लड़ाई होती है, किसी की गुंडागर्दी चल रही है. ये सब कनाइवेंस से होता है जेल स्टाफ की, सब कनाइवेंस से होता है. कनाइवेंस मींस वो चुपचाप देखते हैं, इग्नोर कर देते. दैट मींस दे वांट दिस टू हैपन. और जो सीधे साधे अंडर ट्रायल प्रिजनर्स आते हैं, जो क्रिमिनल नहीं होते बाय नेचर, उनको इनका गुंडागर्दी झेलनी पड़ती है. So this huge violation of the basic human rights of under trial prisoners in such large numbers is made further unbearable by overcrowding, poor living conditions, inadequate healthcare facilities, and torture by other rowdy prisoners, which often occurs with the connivance of jail staff in our prisons. And he highlights the huge injustice caused to the families of the under trial prisoners, languishing in prisons for long years, particularly their children who are denied a normal childhood, proper education, and are exploited by cruel sections of the society in various ways, especially the girl children, and many of whom are forced to take to the path of crime. It's not that a person is a born criminal. Nobody is a born criminal. The social factors are responsible for making a person what he becomes. So in most of the cases, if you read criminology, you would come to know the factors that play a very important role in making a person criminal. There is a separate category of persons who are born criminals. They have different physical traits. They have different physical, physiology. But in most of the cases, that's not the case. That's not the issue. And he highlights, see that the under trial prisoners, they are languishing in prisons for long years, particularly their children who are denied a normal childhood. They are inside the jail. They must not have committed the crime. They are not even likely to be charge sheeted. They are most likely to be acquitted, but they are still behind the bars because their trial is pending. Their children are suffering. They are being denied normal childhood because somebody's father, somebody's mother is behind the bars. They are getting affected. The children are getting affected. They are not getting a proper education because the earning member might be behind the bars. They are exploited by cruel sections of the society because in most of the cases they are looked down upon with disapprobation in the society. We have this terrible habit of judging the people even before the court of law does. So if somebody has been accused of committing a crime, simply we make out a judgment that he must have committed a crime, no doubt about it. I doubted him since the beginning. He must have committed. So there's no doubt about it. So the family is being looked down upon. The sections of the society, the cruel sections of the society, they begin to look down upon such families with disapprobation. Even before the court of law, reaches out a judgment, proper judgment. And even if the court of law acquits a person, then in that case also, the cruel sections of the society, they never spare such families. They never spare such people. Oh, this person went to jail once. Oh, that's great. So this happens, that these are very practical things what are mentioned here and are exploited by cruel sections of the society in various ways, especially the girl children and of whom are forced to take the path of crime. Nobody wants to marry the daughter of a person who has once went to a jail. So while the plight, to use a cliche means a very overused term, of all prisoners is by definition bad. In terms of exposure to disease, it is 10 times worse for under trial prisoners, for the majority of them are and are likely to be found to be innocent. Theirs is a case of innocence in jail and in jeopardy, the jeopardy of a potentially fatal infection contracted while in detention. Is this acceptable in a country which boasts of a constitution in the preamble to which we give unto ourselves before anything else justice? So we have a plight. Plight is an overused term, so it is a cliche. Plight means very बुरी हालत, बहुत बुरी हालत किसी की. जो plight है prisoners की, ये by definition bad है. एक्सपोजर टू डिजीज हो रहा है और 10 टाइम्स वर्स है, 10 गुना ज्यादा बुरी है अंडर ट्रायल प्रिजनर्स के लिए, क्योंकि वो मुफ्त में मारे जा रहे हैं. For the majority of them are most likely to be found to be innocent. There is a case of innocence in jail and in jeopardy, the jeopardy of a potentially fatal infection contracted while in detention. Somebody is just a suspect. There's no proper evidence of him committing a crime. But still, he is contracting a fatal infection for no reason. Is this acceptable in a country which boasts of a constitution? The writer is saying we boast of a constitution, that we have the largest written constitution in the world, which assures us of certain very basic fundamental rights. And we have a preamble which begins with granting to ourselves justice. Does not it says, we the people of India, having solemnly resolved to constitute into a sovereign, socialist, secular, democratic republic, and to ensure to its citizens justice, social, economic, and political. So when on the first priority we intend to give unto ourselves justice before anything else, in a country like that, we are seeing that out of 3.3 lakh under trial prisoners, like out of 4.5 lakh prisoners, total prisoners, 3.3 lakh are under trial prisoners. And out of 3.3 lakh under trial prisoners, almost 2.5 or 2.3 lakh prisoners are not likely to be even charge sheeted or are more likely to be acquitted. So, this 2.2 lakh figure, jo hai, this is the most vulnerable section of prisoners. Because they are staying behind the bars, they are being forced to stay behind the bars during a pandemic, contracting a fatal infection for no reason. So this is not acceptable in a country which boasts of a constitution, which indulges in self-aggrandizement of having a constitution like ours, that begins with a preamble that gives unto ourselves before anything else justice. So the virus cause for an immediate, the virus gives cause the virus gives cause for an immediate review of all the prisoners' vulnerability to the epidemic, starting with that of under trial prisoners who are suffering two privations. One being immobilized, most probably unjustly, and two being tethered to the risk of infection. Okay. So the virus gives cause for an immediate review of all prisoners' vulnerability to the epidemic, starting with that of under trial prisoners who are suffering from two provisions. There are two basic problems every under trial prisoner is suffering from. One is immobility. He cannot move. He is confined behind the bars. He cannot move. Most probably unjustly, because almost at least 2.2 lakh under trial prisoners are being immobilized unjustly. And two, being tethered to the risk of infection. They are being deliberately made vulnerable to the risk of infection. This review has to comprise 100% and repeated testing procedures in all prisons, especially sub-jails, which form the biggest category among them and the least equipped, and an arrangement for the isolating and hospitalization of those testing positive. No prisoner who has tested positive can be allowed to remain within the crowded confines of that venue without transmitting the disease to a progressively rising concentric circles of inmates. When there is a progressively rising concentric circles of inmates, no prisoner testing positive should be allowed to remain inside the crowded confines of that venue. Okay. There should be proper arrangements for practicing social distancing. There should be proper arrangements for hospitalization and isolation of the prisoners testing positive. Okay. And there should also be a proper arrangements for all the prisoners who are not testing positive but have come in contact with some prisoner who has tested positive. Because but above all, the population of prisons has to be rigorously brought down through a salutary amendment, the CRPC Amendment Act of 2005. A much needed section 436A has been introduced. This is very important. The Code of Criminal Procedure Amendment Act 2005, a much needed section 436A, has been introduced in the CRPC, excluding offences for which capital punishment is envisaged. It provides for an under trial to be released on a personal bond, with or without sureties, if the period spent in detention by the under trial has been for more than half of the maximum period of imprisonment prescribed for that offense. Okay. See, एक अमेंडमेंट 2005 में आया था और उस अमेंडमेंट में कोड ऑफ क्रिमिनल प्रोसीजर अमेंडमेंट एक्ट 2005 ने एक नया सेक्शन ऐड किया, इनकॉर्पोरेट किया, वो था सेक्शन 436A सीआरपीसी में, और सारे ऑफेंसेस जिनमें कैपिटल पनिशमेंट है उनको एक्सक्लूड करके, लाइक मर्डर, लाइक ऑफेंसेस अगेंस्ट द स्टेट, ऐसे सारे उनको छोड़कर बाकी सारे अंडर ट्रायल प्रिजनर्स में, जहां पर कैपिटल पनिशमेंट नहीं है, it provides for an under trial to be released on a personal bond with or without sureties. If the period spent in detention by the under trial has been for more than half of the maximum period of imprisonment prescribed for that offense. For example, if he has been accused of an offense for which the maximum punishment is 4 years or 5 years, and this under trial prisoner has already served more than 2.5 according to section 436A, he is supposed to be released on a personal bond. Okay. अगर 10 साल मैक्सिमम सजा है, उसका ट्रायल चल रहा है, तो वो 5 साल से ज्यादा ये गुजार चुका है अगर, तो उसको पर्सनल बॉन्ड पे रिलीज कर दिया जाए. अभी उसका ट्रायल चल रहा है, ठीक है। जहां पे 2 साल सजा है, वो 1 साल से ज्यादा अंडर ट्रायल सजा काट चुका है, अंडर ट्रायल जब वो था, तो अब उसको रिलीज कर दिया जाए। अच्छा एक बात और, जब वो एक अंडर ट्रायल प्रिजनर है और अगर उसको कन्विक्ट किया जा रहा है, उसके खिलाफ एविडेंसेस मिल गए, तो उसमें से पनिशमेंट सुनाने वक्त वो सारा टाइम माइनस कर दिया जाता है जितना वो ऑलरेडी अंडर ट्रायल के दौरान गुजार चुका है एज एन अंडर ट्रायल प्रिजनर। तो वो माइनस कर दिया जाता है, जितनी भी टोटल पनिशमेंट दी जाएगी उसमें से उतना टर्म जितना वो ऑलरेडी सर्व कर चुका है एज एन अंडर ट्रायल प्रिजनर्स बिहाइंड द बार्स, वो माइनस कर दिया जाएगा। तो यहां पर 436 ए में किया जा रहा, ये लिखा जा रहा है कि वो सारे ऑफेंसेस जिसमें कैपिटल पनिशमेंट नहीं है, उन कैपिटल पनिशमेंट वाले ऑफेंसेस को छोड़कर बाकी सब में अगर कोई अंडर ट्रायल प्रिजनर है और वो कि अब मैक्सिमम पीरियड ऑफ इम्प्रिजनमेंट, जितना भी ऑफेंस, जो भी अक्यूज, जिस ऑफेंस में भी वो अक्यूज है, उसकी जो मैक्सिमम पनिशमेंट है उसकी आधी से ज्यादा वो ऑलरेडी गुजार चुका है एज एन अंडर ट्रायल प्रिजनर, तो उसको पर्सनल बॉन्ड में छोड़ दिया जाए विद और विदाउट श्योरिटीज। हालांकि पब्लिक प्रोसिक्यूटर मूव कर सकता है कोर्ट में टू डेविएट फ्रॉम दिस, पब्लिक प्रोसिक्यूटर अपनी अपीयरेंस दे सकता है इसके खिलाफ, ठीक है। The 2005 amendment had two aims: one, decongestion, and two, fairness. इसके दो मकसद थे कि decongest किया जाए ज्यादा से ज्यादा लोगों को और फेयरनेस हो, ठीक है, किसी के साथ कोई ना इंसाफी ना हो। टुडे in our COVID-19 times, if congestion is per se held to be dangerous, decongestion in prisons through a prescribed legal procedure becomes not just a desirability but a duty. It was earlier desirable. It was, in fact, a duty also earlier, but now it is a duty more than a desirability. And I urge the immediate and massive activation of Section 436A without surety so as to benefit all under trials eligible for it. It is not just desirable but axiomatic that 2005 amendment to the CRPC be activated on a nationwide and urgent basis as a penological imperative, a state duty and a human right. And while their release is being actuated, it also follows that even as anyone in a state hospital may rightly expect to be vaccinated on a priority against the virus, so should inmates of the hospitals of correction also. See, we have a सबको एक कैटेगरी बनाई जा रही है, किस किस को कहां वैक्सीनेशन होगा, हर गवर्नमेंट डिपार्टमेंट्स में गवर्नमेंट टीचर्स का होगा, इसका होगा, उसका होगा, एक वैक्सीनेशन ड्राइव है। तो हॉस्पिटल्स फॉर करेक्शनल होम्स जो भी हैं उसमें वैक्सीनेशन ड्राइव किया जाए, ठीक है, वैक्सीनेशन ड्राइव किया जाए कि जो भी प्रिजनर्स के हॉस्पिटल्स हैं वहां पे वैक्सीनेशन ड्राइव स्टार्ट किया जाए प्रिजनर्स के लिए, ओके। अब प्रिजन्स जो है देखिए वो स्टेट लिस्ट में, while prisons is in the state list as is public health, while prisons is in the state list as is public health, the constitutional responsibility of handling infectious and contagious diseases figures in the concurrent list. It is the center that must show the states its concern in this and lead from the front. लेकिन देखिए पब्लिक हेल्थ और प्रिजन्स ये दोनों स्टेट लिस्ट में है, लेकिन इन्फेक्शियस और कंटेजियस डिजीज को कंटेन करना ये कॉन्करेंट लिस्ट में है, दोनों की जिम्मेदारी है। तो यहां पे वी नीड अ कॉन्सोनेंस बिटवीन द स्टेट गवर्नमेंट्स एंड द सेंट्रल गवर्नमेंट, and the central government should lead from the front in this case. So it's all about the prison reforms. If you have any questions, you have all liberty to put the questions now. There's a question from Aslesha Sena. Can't the National Human Rights Commission put pressure on the prisons for better treatment of prisoners and make them accountable? Yes, obviously. They have done so. And they have done time and again. There are plethora of reports of National Human Rights Commission. I have been an intern at National Human Rights Commission during my post graduation. Like in the last year, I was an intern at the NHRC, and many sessions were conducted on improving the prisons. The NHRC showed us how, and we have constituted various committees time and again. What reports came up and what suggestions were made by the NHRC, and you know. Like various sessions were also taken by various human rights lawyers, IPS officers who have been working on prison reforms. But all these as agencies, all these people can make suggestions, they can make recommendations to the governments. But ultimately, at the end, who has to practically execute those recommendations? It is the state governments, it is the central government that has to look into that. These kinds of things should be properly implemented. So at the end, National Human Rights Commission have put pressure, no doubt. But a typical Indian government never pays heed to these kinds of recommendations. Committees are constituted, reports come, and they just simply pile up on the tables of the ministers. They hardly pay any heed to what the NHRC, a great institution like NHRC, has recommended. And obviously, there is a sense of accountability also. But this issue is not put in the public domain. This should be put in the public domain, actually. This should become one of the grounds for holding a political party responsible, at least. Bringing these kinds of reforms is the ultimately the responsibility of the state governments and the central government both together. They have to make sure that these recommendations are properly implemented. So I think that was the only question. So I'm signing off then and ending the broadcast. One more question by Aslesha. Isn't there a procedure for the speedier disposal of under trials? We have certain category of offenses like POXO, Prevention of Children from Sexual Offences Act. Under POXO Act, we have certain time limitations, time bound trials, and various other special laws also. We have time bound trials, but mostly in general criminal law like IPC, we do not have time bound trials. The trial is not time bound. Like judicial custody period is time bound, but also at the in the end of the section it says you can go, it can go indefinitely. So basically there is no proper mechanism for the speedier disposal of under trials except in some special laws like POXO. There's no proper mechanism, and proper means a full-fledged defined category should be there, that this particular offense or this particular trial has to be completed within this particular time. It has to be completed at anyhow, or otherwise the judges should be held accountable if not completing the trial within the stipulated period. They should be held accountable. But we do not have that mechanism, unfortunately. Okay, welcome all, and hello to Shamik Saha and all the people. Good evening. Bye bye.